Well, welcome to Chapter 3, Equal Employment Opportunity. This chapter covers the legal aspects of HR in a general sense. In other words, Chapter 3 details the laws affecting human resource management in organizations. What laws are applicable? How do they impact HR decisions and actions? And to a certain extent, how can we in an organization comply with the law and minimize the risk of noncompliance? The authors start the discussion by covering a few very important terms you should know well. Protected characteristics, they're generally called protected class, details what types of situations are covered by employment laws. For example, there are laws that protect individuals and groups due to their race and their age and their religion and many more characteristics. In essence, human resource management decisions, things dealing with hiring and firing and promotions and pay and other HR decisions, cannot consider these characteristics in making such decisions. Individuals with those traits are protected from discrimination because they have those traits. Pay attention to disparate impact and disparate treatment defined in the text. I discuss both of these terms in greater detail in my lecture as well. Some of these laws are broad-based, meaning that they cover a wide range of characteristics, while others are a little more specific in their coverage. Some are almost too general. We will see this material over and over in the future chapters, and more context will be provided when we discuss them there. This chapter provides the base for those deeper discussions and applications. The same can be said for sex, gender, specific laws. In this section, pay particular attention to sexual harassment in that it represents a major risk factor for all organizations. And we can see how sex and gender laws are playing out in our society today. It's in the news all the time with HB2. I also believe that the ADA is a major risk area due to the expansion of the definition of disability promulgated by the ADA Amendments Act. Also pay attention to essential functions, reasonable accommodation, and undue hardship. Those terms are important. Age discrimination presents a greater risk now since our population is aging and people are staying in the workforce longer today than in previous years. Likewise with the consideration of religion. The remainder of the chapter covers laws that are even more specific, such as immigration and military discrimination. They are no less important than the previously discussed laws, but they cover a smaller percentage of the population. Finally, pay attention to the discussion of diversity training. Originally, diversity training was seen as a major tool for mitigating the risk of discrimination. Today, it still has value, but its effectiveness is coming under much closer scrutiny. My lecture provides some real-world examples and experiences of how to maintain compliance with these pervasive laws and discussion on how laws should never prevent an organization from doing what is right as long as it's done in the right way. Take some time to nail down these concepts and understand my examples. You can be sure you will see these laws in future chapters, but more importantly, they will impact your decisions and your chance for success in your career. I'm sure everyone has heard of equal employment opportunity and specifically the EEOC. The text covers the topic well, and understanding this material can go a long way towards preventing your facing the consequences of real or implied discrimination in your career. I would like to cover some of the more subtle aspects of EEO law and policy. Some are intended to provide you with a different insight to such activities, and others are my observations and opinions, of which I'm sure not all will agree. But that's what makes for a good discussion. Let me start with the distinction between disparate treatment and disparate impact. It's my assertion that disparate treatment is much easier to observe, diagnose, and treat than disparate impact. Disparate treatment is also easier to explain and define to other members of the organization than disparate impact. Disparate treatment normally is displayed when an individual or group of individuals are treated differently. They don't receive promotions. They have different hiring criteria applied. They are paid less, or their working conditions are not equal, or some other disparity is apparent. In other words, an individual or group is treated differently. As a manager, I can usually observe and diagnose that problem with little difficulty. I can readily see it if I'm paying attention. Disparate impact is present when members of a protected category are substantially underrepresented as a result of employment decisions that work to their disadvantage. There are two problems for management with this definition. First, it is often difficult for a manager to see underrepresentation in a protected group. What is adequate representation? Is proper representation of females 20% or 30% or 60%? It's easy to see disparate impact if an organization has 10 supervisors and all are white males. In that case, all minorities are underrepresented. But what if an organization has 100 supervisors and 50% are female and 50% are males? Are females underrepresented? Well, the answer may be yes if 80% of the employees are female, or the answer may be no if only 10% of the employees are female. So proper representation is defined by the number of individuals who should be in a category versus the number of individuals available. And the number available is often in dispute. I worked for a large corporation that was involved in a dispute with the EEOC over hiring practices in one of its manufacturing facilities. The facility was located in a rural community that was approximately 25 miles from the larger city. The minority population in the surrounding community was 10% of the total community. The company employed around 15% minorities in its facility. By all measures, minorities were not underrepresented. The EEOC claimed that the facility should have recruited from the larger city and not just within the surrounding community. When the minority population of the larger city was included in the hiring area, the minority population increased to over 20% of the total population, and the company was underrepresented against that criteria. So what was the normal recruiting area of the facility? The company and the EEOC obviously disagreed. From a practical standpoint, the minority population in the larger city was concentrated in an area about 35 to 40 miles from the facility. The facility paid competitively with the local community, but lower than the norm for the larger city. Unemployment was around 4%, which is considered near full employment. Therefore, it was difficult to find qualified available employees and impossible to hire qualified employees who were willing to travel such a distance to work for less wages than they could obtain closer to the city. Were minorities underrepresented? In my opinion, no, but the EEOC case went on for 10 years without resolution. Underrepresentation is often in the eyes of the beholder, while disparate treatment has a much clearer result. This is not a defense of discrimination, but it is a caution to those who practice management. Guard against both disparate treatment and disparate impact. But realize, you may be engaging in disparate impact and not even be aware of the danger. Caution is in order. Obviously, discrimination is the commonality in this discussion. One dictionary definition of discrimination is an act or instance of discriminating or of making distinction. The power of making fine distinctions. Another definition includes the practice of unfairly treating a person or group of people differently from other people or groups of people. Discrimination has gotten a bad rap. Should we or an organization discriminate? Well, we discriminate every day. We choose one group over another. We choose one individual over others. We discriminate when we vote. We discriminate when we choose to donate to charities. We all discriminate all of the time. Discrimination is the essence of good business. Being able to discriminate in who we hire, who we promote, who we pay, and how much, and how many other normal business practices is not only important, but expected and required. I expect my doctor to hire the best lab techs, nurses, and specialists, regardless of their race, sex, national origin, etc. I expect my local police department to hire and promote the most effective police people, regardless of their race and sex, etc. And for years now, businesses have been whining about EEO laws restricting their activities and not allowing them to hire the best. EEO laws do not forbid discrimination. They forbid discrimination for the wrong reasons. Organizations can still hire the best people and promote the most qualified. They merely have to demonstrate that the decision was made disregarding race and sex and national origin and all of the other protected class factors. Organizations must merely prove that the decision was based on actual job criteria and not on the opinion of one manager or supervisor. Now, don't misunderstand. There are aspects of the EO law which I disagree, but these laws don't prevent managers and leaders from fulfilling their obligations to the organization. When confronted with such whining by managers, I always responded, you can do anything you want to do as long as it's the right thing and you do it in the right way. Failing to hire or promote someone merely because they are female or black or Latino or older or pregnant is not right, and read that as ethical or moral. Failing to hire those who are female or black or Latino or old because they are not qualified is the right thing to do, and that decision can be defended. I'll give you a quick example. I worked in a manufacturing facility in which the maintenance department included one black female. This young lady was a very poor employee. Her attendance record was the worst in the department, including both males and females. Her work included numerous costly errors on which she was counseled, and they were well documented. She engaged in constant conflict with employees within and outside the department, both male and female, and employees of all races. She was counseled for over a year and given ample opportunity to improve her attendance and her work performance. To complicate matters, she was pregnant and she filed a sexual harassment charge against her white male supervisor. The latter action caused an uproar throughout the facility because the supervisor was highly respected and well liked. I conducted a meticulous and well-structured investigation of the sexual harassment case and determined that there was no evidence of any sexual harassment. With the results of the investigation, she threatened a lawsuit, and I invited her to exercise her rights. Finally, her attendance and performance became worse, and I terminated her employment. Understand, this is a black, pregnant female who filed a sexual harassment charge against her supervisor, who was the only black female in the department. One would expect this to be a difficult case to defend due to all the protected classes this young lady represented. As expected, she filed a charge with the EEOC, and I received a notice that an EEOC representative would investigate the case. I submitted our documentation of the case. Documentation is essential in all aspects of human resource management. And I also submitted a long list of witnesses to represent the organization's position. After reviewing the documentation and hearing the witnesses, the EEOC representative indicated that the case had no merit and dropped all charges against the company. Now, that's not the end. Even if the EEOC stipulates that the case has no merit, an individual has the right to sue on their own for damages. I know that this young lady sought the services of several attorneys in the community, and not one elected to take the case because they felt it also had no merit and thus no profits for the attorneys. Again, you can do anything you want as long as it's the right thing and done in the right way. Now, the text enters into a discussion of broad-based discrimination laws, and I would encourage you to read and understand those as well as the laws governing sex and gender. These are broad-based and don't begin to cover the variety of regulations that are applicable to enforcing these laws. When a law is passed through Congress, think in terms of the Affordable Care Act, the law actually outlines the intent of the law, but not the full detail. For example, I remember when the Americans with Disabilities Act was passed, there was great confusion as to how the law and what the law actually meant. No one knew specifically what was required to come into compliance with the law. The law, as written by Congress, was too broad in general to spell out any operational specifics. What is a disability? Who is covered under the Act? What are the penalties for noncompliance? The questions went on, and no answers were forthcoming. You see, Congress passes the law on to the bureaucrats who promulgate regulations providing details, at least as many details as they can think of. Under the original law, obesity was not covered specifically. But was obesity a disability by definition? The bureaucrats ruled that obesity was not covered. Someone who was obviously obese disagreed and filed a lawsuit against a company. The courts ruled on that and other cases that obesity was a disability in those particular circumstances. The confusion begins when courts rule differently on the same general issues such as obesity. Some courts ruled that obesity was covered and other courts ruled that it wasn't. Still others ruled that it was covered in some instances but not in others. Well, is it covered or not? Well, it depends. As you can see, human resource management legal issues are not clear and always up to interpretation by governmental regulators and bureaucrats in the courts. And those rulings were observed by bureaucrats who ultimately changed the rules and regulations to represent the court rulings. First comes the law by Congress, then come the regulations by bureaucrats, then come the ruling by the courts, and, as in the ADA, comes more laws by Congress. Think of the ADA Amendments Act. Although laws may provide clarity for some who feel wronged, they provide mass confusion and great risk for those who try to comply with the laws on a daily basis. Such is our system, and non-compliance is not a solution. That said, complying with laws and regulations can be like chasing a moving and ever-changing target. This confusion begs the question, why do we have all of these regulations and laws? Why do we have laws that protect minorities and females and pregnant females and people from other countries and older people and people of various religions and disabled people, etc.? Simply, we have laws protecting them because many people and organizations have actively discriminated against these groups. Organizations can thank no one but themselves for having restrictive laws. And it is easy to blame these discriminatory practices on evil business people who care about nothing more than money and power. Well, I'll tell you, those who hold that opinion are engaging in misconception to the same extent as organizations whining about the laws preventing them from meeting their obligations. Most leaders and managers do not set out to openly discriminate against people in protected classes. Most leaders and managers are good, decent people who are trying to compete in a global marketplace and also maintain an ethical position in an ever-changing national culture. Their intent is to provide a successful organizational culture which can afford a positive contribution to customers, employees, and communities. Sometimes they make mistakes. Sometimes they don't recognize the right action or the wrong action. Sometimes they need objective guidance away from the business fray. And often when confronted by the concept that they may be inappropriately discriminating against a person or group, they are horrified at the thought. I worked for an individual I'll call Bob. Bob was one of the finest leaders I've ever met and one of the finest persons I've ever met. The organization was temporarily without a purchasing manager, and a young female buyer, I'll call Mary, had accepted most of the manager roles. She was dealing on a new level with vendors, legal issues, other managers, etc., and she performed very credibly. The purchasing manager was scheduled to return to work, but in the meantime, she ensured that all aspects of the purchasing operation remained afloat. The department pay structure allowed for a high-level Buyer 1 position and a lower, less experienced required Buyer 2 position. The young lady was in the Buyer 2 position. I approached Bob and proposed that we move Mary to the Buyer 1 position as a promotion with a pay increase. Bob argued that she still didn't have enough experience and acknowledged that her performance was exemplary, but she just wasn't ready. We argued and discussed, mostly argued, and I left Bob's office declaring that I believed he was discriminating against her because she was a female, and if she was a male, he would have had no problem with the promotion. His anger at that comment was barely under control. He declared unequivocally that he did not discriminate, and I was out of line, implying such. About an hour later, Bob came to my office and said that my statement had bothered him greatly. He said he'd been thinking about it and agreed that he was discriminating because Mary was a female, and in his mind, he had set up different criteria for males and females. He didn't even realize he was doing it. He was embarrassed and disappointed in himself. He agreed that, of course, the promotion was in order and we should announce it as soon as possible. Now, I was not embarrassed or disappointed in him. I was overjoyed that my previous assessment of his goodness was reinforced. That is why I consider him one of the finest leaders I have ever encountered. He was able to analyze himself, recognize his weaknesses and flaws, correct them, and do the right thing. His apparent goodness was his greatest strength. He didn't realize that in one situation he was discriminating. Don't you sometimes do inappropriate things and don't realize they are inappropriate until someone else points it out or until you can look at it later? It doesn't make you evil, it makes you human. I know there is discrimination in organizations, but I also believe the incidents of discrimination are becoming less. One reason is more awareness, and another reason is the risk of consequences, both monetary and social, for discriminatory practices. A third reason, I believe, is that organizations are full of good, decent people who want to do the right thing. Now, sexual harassment is another matter. I believe that one may engage in discriminatory activity by habit or misunderstanding, but sexual harassment is intentional. And while discrimination is often a result of poor practices that are perhaps allowed by a culture, I have found that consistent sexual harassment in an organization is a result of a permissive culture and weak management. In my experience, the only way to realistically prevent sexual harassment or to clean up a culture that permits sexual harassment is to announce to the organization on a regular basis that such behavior will not be tolerated, emphasize that the consequences for such behavior can include termination of employment, and when an incident occurs, investigate, draw conclusions, and take appropriate action. It is most important that employees understand that there is zero tolerance for harassment behavior and that those reporting such behavior will not experience any retaliation. As discussed in the text, there are two kinds of sexual harassment. Quid pro quo, which means I give and you give. In other words, I give you more money, a promotion, more break time, etc., and you give me sexual favors. This type of harassment is usually between management and employees. It is generally individual in nature and is diminishing in frequency due to strong enforcement and major consequences. Hostile work environment is more common and broader in nature. It can involve direct behavior between individuals, comments and jokes of sexual nature, or anything that offends or interferes with an individual's ability to perform work. When we think of sexual harassment, we generally think of males harassing females, but today we see an increasing incident of females harassing males or females engaging in offensive behavior that creates a hostile work environment for all. Same-sex harassment is also on the increase. By definition, sexual harassment is a form of discrimination. Perhaps the best method of preventing such behavior is regular training. Such training should include examples of the consequences of harassment behavior and the procedure for reporting harassment. I have conducted training for both managers and supervisors. Training raises awareness and also reinforces the no tolerance culture. Some other areas of discrimination that are also problematic to organizations are age discrimination, disability discrimination, and religious discrimination. Age discrimination is on the rise because the population is getting older, as I said before. Another contributing factor is more elderly people staying in the workforce longer and seeking employment at older ages. I believe that age discrimination exists and is going to become more prevalent in the future. Disability discrimination is also increasing. This increase is at least partially due to an expanded definition of disability through the ADA Amendments Act. more people have disabilities and therefore discrimination increases. Religious discrimination in the workplace is not as common as some previously discussed practices, but has the potential to become greater as controversy over religious expression in society as a whole becomes more prevalent. The problem with this type of discrimination is that it involves a part of our lives that is deeply personal and carries such a strong emotional aspect. And finally, I could make some observations on immigration law, but I'm not sure where to start. Those laws seem to change almost daily. However, it does point out a topic on which I will comment. It is a topic we should discuss on the discussion forum as well. The fact that immigration laws change frequently demonstrates a real problem with legal compliance in all business situations. As our government grows and laws and supporting regulations become more prolific, as bureaucracy intrudes deeper and deeper into our lives, and throw in the court rulings and compliance becomes a moving target that moves ever faster. I used to tell managers that one can be sure that somewhere, someone is breaking a law or regulation every minute of every day unintentionally. First, it is virtually impossible for everyone to know all of the laws and regulations, and second, it is impossible to be in full compliance and remain competitive. That doesn't mean that organizations should give up on compliance, but they must understand that there's always a risk present, and the organization should choose to ensure complete compliance with the most important laws and regulations. I realize this does not sound like good advice from someone who's been in the business, and particularly in the HR business, for over 35 years, but it is the truth, and the truth in all aspects of our lives. We have reached a point where there are so many laws we cannot hope to remain in compliance all of the time and dispel all of the risk. Did you follow all of the speed limit signs on your travels today? Is your home in compliance with all zoning laws, utility specifications, codes, rules, even those you don't know about? It is not only a matter of following all of the laws, there are so many laws impacting our daily lives that government officials have chosen not to enforce some of the laws while actively enforcing others. Such is the case with the immigration laws. How about those laws we read about that have been on the books for decades and no one knows where they come from? Obscure laws that forbid spitting on the sidewalk or prohibit displaying certain signs in a yard, or laws that require specific behaviors. They're there, but not enforced. Again, I'm not implying that organizations or persons should ignore the law, but we must ensure that we are in compliance with the important laws. How do we know which laws are important? There's a simple answer that I have followed for many years in many companies. Follow good values, morals, and ethics, and the law will take care of itself. Do the right thing always. The question remains, given the discussion above, have we reached a point where government has intruded into our lives too much? Is more government better or worse for our culture and society? How much government is enough? The text covers other laws that you should not ignore in your studies, such as the Uniform Services Employment and Reemployment Act, and also includes an interesting discussion on diversity training. But one fact we should clearly take from Chapter 3 is that discrimination is clearly an important factor in all organizations and a problem in some. Appropriate discrimination in choices and decisions is critical to success. Inappropriate discrimination carries direct financial consequences and additional losses due to lost opportunity, interference with business processes, and damage to culture and reputation. Inappropriate discrimination is wrong and should not be tolerated. Although laws are pervasive in our current society, there are many tools available to assist in making good choices, discriminating legally between those choices, and functioning in a legal, moral, and ethical manner. Many of these tools will be covered in subsequent chapters, and this chapter provides the basis for your understanding of the importance in finding ways to run the organization, make appropriate choices, and still, for the most part, remain in compliance.